I welcome you all to lecture number 3 of Indian Partnership Act CA series. I am your mentor Shekhar Gehlot. These classes are sponsored by Srijender Bank Zone. Now we are discussing our Indian Partnership Act and this is lecture 3. In previous lectures we have discussed in detail about what is a partnership, what are the essentials of partnership and what are the distinctions between a partnership and a other kind of entity and what is a different kind of what are partners, how many types of partnerships are there and what are different type of partners. Now with this chapter, we will begin with relation of partners to one another. Okay. Now we have discussed different types of partnerships as well as different type of partners like sleeping, nominal, and holding out and active and okay like these partners in profits only. But now it is time for us to understand relations of partners to one another. Okay, now when we are working in a team, okay, as partners, we are partners. 4 5 people, they set up a partnership, they are partners. Now till now we have discussed the relation with the partnership. Okay, what is the relation of a partner with a partnership? Okay, till now we have understood this, but now what is the inter se relation? What is the relation between one partner and the other partner? We will begin with this. This is a kind of a flow chart which will explain what we are going to study, okay, in this chapter. Meanwhile, you take a look and then we will start with our chapter. Now, what we are going to study in this chapter? We are going to study mutual rights and duties. Okay, what are the mutual rights and duties between one partner and the other partner? Okay, when we are partners, definitely we have some rights as well as duties towards each other. Okay, when we have a right, we have a duty as well. Rights and duties go hand in hand. Relation of partners with third parties. Okay, now we understand what is the relation of a partnership with a third party. A partnership is relation with a third party, but what is the relation between a partner, an individual partner of a partnership with a third party? Implied authority of a partner, which can be further classified into two chapters, two units. One is act beyond the implied authority. Okay, there is something called implied authority which each partner has. Now there are two kind of acts when he is acting beyond his implied authority. The other one is extension and restriction of partners' implied authority. We will discuss under what circumstances this implied authority of a partner can be extended or restricted. Who will do that? Definitely the partnership or the collection of other partners. Then how to admit a new partner, that is the admission of a new partner. How a new partner could be admitted to partnership. Liabilities to third parties. What are the liabilities of partners towards third parties? Okay. Legal consequences of partners coming in and going out. Like we had studied in the previous chapter, that there are two types of partners. I mean, out of so many type of partners, two type of partners are incoming partners and going out or outgoing partners. So we'll understand what are the legal consequences when a partner comes in. when a partner joins in already running partnership, or when a partner leaves a partnership which is a running partnership. Then it has five types of consequences. Induction of a new partner. Okay, when a new partner comes, it will be induction of a new partner, or retirement, because everyone has a retirement age. Mind is limited, it has a limited potential and body. At certain point of time, everyone has to retire. Expulsion. Sometimes you may be working against a firm. You may be a partner into the partnership firm, but your work is not in the best interest of the partnership, so you may be expelled as well. Insolvency. What will be the effect of insolvency upon the partnership? Okay, if there are six partners, one of them has become insolvent. Insolvent, like we all understand, is someone who is not able to discharge his liabilities, whose debts have increased, whose debts are more than his assets. Or what is the impact of death? Okay, death of a partner. What is the impact of death upon the partnership as a whole? The Partnership Act contains various provisions regulating the relationship between partners. Okay, it contains various provisions. And now we'll discuss all those provisions in detailed manner. The first one is general duties of partners. Section 9 talks about general duties of partner. Okay, we are not talking about any special duty, only general duty. Sorry, only a general duty. Okay, partners are bound to carry on business. First of all, you must understand when we are talking about general duty. General duty, it means it is applicable to all partners in all type of partnerships. Okay, now when I say this, that it is applicable to all type of partners in all type of partnerships, I mean to say that there may be some special duties as well, like some partner may be a managing partner, or someone may be an auditing partner, etc. They may have a special role, they may have special duties as a partner, as a managing partner, or as an auditing partner. But we are not discussing those special duties, which are usually role specific. Okay, they are specific as to what role that partner is playing. If he is playing the partner role of managing partner, then definitely he is going to have more powers. When he'll have more powers, he'll have more duties as well. Similarly, when someone is an auditing partner, by the name itself, he is going to do a lot of accounting of the firm. Okay, so but these are general duties which are applicable upon all partners. That means a normal partner who is not having any special role like an auditing partner or managing partner will also have to follow these duties. An auditing partner will also have to follow these duties, and a managing partner, or you may have more names for such partners like a procurement partner. Okay, hiring partner, firing partner, salary partner, remuneration partners, so many kind of partnerships and so many names for the partners. Okay, so it may be there, special roles may be there, but these duties are applicable on all kind of partners. Okay, these are basic duties which everyone being by virtue of a partner has to fulfill. Partners are bound to carry on the business of the firm to the greatest common advantage. Okay, partners are bound to carry on the business of the firm to the greatest common advantage. This is duty number one. Okay, duty number one is carry on business greatest. Greatest. Now the key word here is common advantage. Now whatever a partner would do, okay, whatever a partner is doing, whatever role he is playing, whatever he would do in the firm, his ultimate aim should be the greatest common advantage. We are not talking about a individual advantage. You
It's
must
8
have heard a
o'clock.
lot of time that cricket is a team game. Okay. Now sometimes some players in the cricket are accused of playing for individual self. Like some player is not playing for the teams. We say that sometimes he's just trying to hit his century or the half century. He's least concerned about the team score. Okay. So this is the case with the partnership. Partnership is a teamwork. So whatever a partner has to do, he has to do it for the greatest common advantage of the partnership and all partners as a whole. Okay, so he has not to play the for individual benefit or the gain. Okay, this is the first duty of the partner: to be just and faithful to each other. Let's highlight this word just and faithful. Second duty, now we have our second general duty: being just and faithful. Now, this being just and faithful are two different words. Just means you are fair. Okay, you are fair, you are honorable. What you are doing is always you are doing it with fairness, equity, equality. Okay, these principles you are acting. And faithful. Faithful means you are committed, you are dedicated to whom? To each other. You are dedicated not to yourself, but you are dedicated to your work and to your fellow partners. This is your second duty: being just and faithful. You have to be fair as well as committed, dedicated, righteous, courageous, okay, true man, and to render true accounts and full information of all things affecting the firm to any partner or his legal representative, and to render true accounts. He has to render true accounts. Now we have our third duty. He has to render true accounts. Like this is a managing partner. Whatever he does for the firm, he has a lot of control over the firm. Okay, so whatever he does, he must have true accounts. He must write down everything. Okay, sometimes someone is a procurement partner. He is procuring, or a purchase partner. He is purchasing the stuff for the partnership firm or the raw material. Okay, so he must render the true account. He must not force or fabricate the accounts. He must tell the true accounts, true amount of the purchase made. Similarly, there may be a sales partner who's conducting sales. He must give the true figures of sales. At what cost the firm has sold the products, what is the profit the firm is making, what new clients firm could make, such and such. He should render true account and full information of all things. He must provide full information of all things affecting the firm to any partner or his legal representative. Okay, he has to render full information. Now let us assume we have a partnership. There is a partnerships XYZ. There are three people, they are having a partnership. Now they are entering into a contract with another firm named KBD. Okay. Now this KBD firm, this person B is a partner in this KBD firm. They are doing business with this XYZ firm. Now this Z is the father of B. Okay. So XYZ, Z is a partner in XYZ firm. His son is partner in KBD firm. So now Z must disclose this to X and Y. That C, we are doing business with KBD. B is my son. Okay. And B also should inform K and D that we are doing business with XYZ firm. Z is my father. Okay, so that tomorrow there may not be allegations of unnecessary favoring by XYZ, by Z to KBD firm, or KBD paying extra money to the firm of XYZ for the material available in the market, so that tomorrow there are no such corruption issues. Okay, so he should disclose it. See that this is my son, and if you want to do business, do it as per our own volition. So these are the general duties prescribed by Section 9 of the Indian Partnership Act 1932. Now let's do the analysis of Section 9. The partners should carry business of the firm to the greatest common advantages, and like we have discussed, greatest common advantages. It has to be uniformly for all the partners. And later, they should render to any partner or his legal representative full information of the things affecting the firm. Okay, whatever is affecting the firm. Suppose he comes to know that there is some legal issue. Okay, some partner has a legal knowledge or is a law graduate. Other partners don't have a sound legal knowledge. So this partner who has a legal knowledge should inform about the legal loopholes or something which may trouble the firm later to other partners that this is the legal lacuna in the structure of the firm and we must check it. A partner must observe the utmost good faith in his dealings with the other parties. A partner must observe the utmost good faith. We are not talking about good faith. We are talking about utmost good faith. Like something bigger than good faith. Something more than fairness. Utmost fairness, okay, in his dealings with the other partner. So you have to be very truthful, okay, with while dealing with the other partners. This is what Section 9 tells all partners across all kind of partnerships to all kind of partners. These are not special duties, okay, like we discussed earlier. All the partners are bound to render accounts to each other, but where some of the accounts are kept by one of them. Now, sometimes it may happen that the partnership has 4 or 5 offices. Now there are 5 offices for a partnership firm and 5 partners are there. So every partner is sitting in one office each. So now you cannot have accounts in all the offices. You cannot keep accounts in all the offices. Definitely you will keep all the accounts of the partnership in one office. Suppose you are keeping the account in accounts are kept in A. A is a partner, A's office. Okay, so A is having the custody of the accounts. So now he must maintain the accounts in a proper manner, and whenever required, he must furnish the required information to all the co-partners, that is B, C, D, and E, who are sitting in other offices who are not having easy access to the accounts because accounts records and books are kept in A's office. So A must maintain those accounts in a valid manner so as to whenever required other partners could see it or check it. In a transaction between partners for sale and purchase of a share in the business, if one of them is better acquainted with the accounts than other, it is his duty to disclose all material facts. Okay. Now one partner is trying to buy out the share of another partner. Okay, the valuation is, suppose he is buying the share of another partner for 1 crore rupees. But the third partner who knows that the value should be 80 lakh. So now he must inform this partner that what share you are going to buy for 1 crore should be valued at 80 lakh. He should not withhold his information there. He should not remain silent. He should inform the other partner that you are valuing it higher than the market. The market value of this is 80 lakh and I have knowledge of this stuff. Okay, so this is at most good faith we are talking about between the partners which they have to observe. Now the second one is duty to indemnify for loss caused by fraud. That is section 10. First of all, understand what this word indemnify means. Indemnify is a kind of insurance. Okay. Now this is the crux of what is indemnity of a partner towards each other. Suppose there are two partners, A and B. Now we have a concept in the partnership which says partners' liability are unlimited. Okay, and they are principal and agent to each other. So now due to A's fault, okay, A's fault, B has suffered a loss of 1 lakh rupees. Suppose there was a total loss of 2 lakh rupees, but because there's a distribution or division of losses equally between the partners. So A will bear 1 lakh rupees loss and B will bear another 1 lakh rupees loss. But B has suffered this 1 lakh rupee loss due to the fault of A. Now A must pay 1 lakh rupees to B. Okay, this is indemnity. Indemnity means insurance. I am going to insure my partner that tomorrow, if he suffers a loss due to my fault, I will make the payment to him. Okay, that is called duty of indemnity for loss caused by fraud. Loss caused by fraud only, but it is not that in regular course of business, if due to my dealing some losses caused to the other partner, then I will pay. No, that is not the way we are dealing here. Partners are bound to suffer the loss together and they are entitled to share the profits as well. We are talking only about a special situation. Okay, now this is a special situation only. And what is this special situation? Situation of fraud. Situation of fraud by one partner. We are not talking about general duties anymore. This is a special duty. Special duty is loss caused due to fraud. There may be okay. There may be business losses suffered by firm because of a decision of one partner. Suppose one partner said that let us stock sugar. Let us take a lot of let us buy sugar in bulk quantity and stock it in the godown so that tomorrow when the prices are high we will sell the sugar and we will make the profit. But ultimately eventually what happened, sugar prices plummeted, the price of sugar went down, and when the price of sugar went down, the firm was supposed had to sell the sugar in a lower price. Now the firm has suffered a loss, and now because firm collectively has suffered the loss shall be distributed between all the partners. When we are distributing the loss, each partner has suffered some loss. Whose decision was it? It was decision of one partner alone. But because all partners agreed and there is no fraud in this case, if there is no fraud, then he is not liable to indemnify the other partners. This is a purely business loss. Business is a game of decisions. Sometimes your decisions work, sometimes your decisions don't work. So when your decisions don't work, that does not mean that you have committed a fraud. Okay, so there is no case of fraud here. When a partnership suffers genuine loss due to a genuine act of a partner, then this partner has no duty, no moral as well as no legal duty to indemnify or to insure or to pay back the loss suffered by other partners. Here we are talking about only situations where duty to indemnify for loss caused by fraud. Suppose this partner has committed a fraud and due to that fraud, the firm has suffered a loss. Sorry, I again and again keep on saying company because company is a very usual term. Sorry. So the firm has suffered a loss. So due to the fraud, loss is being suffered. That means this was an avoidable act. Okay, the act of fraud was avoidable, he could have avoided, and whatever loss we are suffering is purely because of this person's fraudulent act. Now, that loss other partners need not suffer. They can get it back from the partner due to whom such loss is caused. Okay. Every partner shall indemnify, shall, it is shall, that he must indemnify the firm for any loss caused to it by his fraud in the conduct of business of the firm. Now the law says, section 10 says, every partner shall indemnify. That means tomorrow, if some partner says, I will not indemnify, I will not pay, though I have committed fraud and you people have suffered a loss, but I will still not pay you people, then that means other partners of the firm can take legal recourse. They can legally approach a court and say that please direct this person to pay us because we have suffered a loss, and court will definitely order in the like manner. The partner committing fraud in the conduct of the business of the firm must make good the loss sustained by the firm by his misconduct, and the amounts so brought in the partnership should be divided between the partners. Okay. An act of partners imputable to the firm or principal of agency which is a fraud on his co-partners entitles the co-partners as between themselves to throw the whole of the consequences upon them. Okay. Now what this says, it says if he has committed some fraud and due to that fraud some profits have occurred to firm, then firm is entitled to distribute the profits between the partners. Okay. Then this partner alone cannot keep the money and say that because it's my fraudulent act, I will take the profit. No, then he'll have to distribute the profits. But if in case losses are occurred due to the fraudulent act, then these whole losses could be thrown up at one partner alone. That because this is your fraudulent act and we have suffered loss, now you bear this whole loss. Okay, so this rule discourages one partner to commit fraud with the other partners because he knows that tomorrow all the losses will be ultimately borne by him. Determination of rights and duties of partners by contract between the partners. That is now section 11. It says determine your rights and duties. You can have contract. Okay, you can have a partnership deed like we discussed. And in that partnership deed, just like we have a memorandum of association for the company which lays down the objects of the company, and we have articles of association of the company which determines how the company will function, what is the internal management of the company, what will be the tenure for the director, how the auditors will be appointed, at what time AGM shall be held, etc. Similarly, in a partnership firm, when you enter in a partnership deed, you can get a contract in which you can delimit. Okay, delimit means you can prescribe different duties and rights to different partners, and every partner must obey their kind of duties and also are entitled to enjoy the rights allowed to those partners as per the contract. Okay, so ultimately, what right and duties partners are going to enjoy, special rights and duties, privileges partners are going to enjoy qua the firm and as well as to each other. You can determine it through a contract in a partnership deed. Okay, so now section 11 talks about that only. Subject to the provisions of this act. This means that in case you are having an agreement which goes against the provisions of this act, okay, then that part of your agreement will not be read, will not be valid. Okay, then the portion of the act will be operative. Okay, the mutual rights, mutual means inter se, inter between partners, and duties of partners of a firm may be determined by contract between the partners, and such contract may be expressed or may be implied by a course of dealing. So this kind of a contract may be expressed as well as may be implied because we see there is no such requirement of written thing at all. Even for setting up a partnership, you can set up a partnership through a oral or implied or a conduct agreement. Okay. Such contract may be varied by consent of all the partners, and such consent may be expressed or may be implied by the course of dealing. Okay, by the course of dealing, you will get to know whether this thing has happened or not. Agreements and restraint of trade. Notwithstanding anything contained in Section 27 of the Indian Contract Act 1872, such contracts may provide that a partner shall not carry on business other than that of the firm while he is a partner. Now, Section 27 of the Indian Contract Act. ICA is Indian Contract Act here. So Section 27 of Indian Contract Act says agreement in restraint of trade are void. That means you cannot have such kind of agreement which restrict a person's ability or his right to carry on the trade of his own choice. That means everyone is free to carry on the trade of their own choice. Similar is the case with the partner. Partners are free to carry on whatever trade they wish to carry. Okay, but there we have section 11 of the Partnership Act, which provides a exception to the section 27 of Indian Contract Act. Please hang on. So section 27 says you cannot have an agreement which restricts someone from entering into a from carrying on a trade. Okay. Then comes this section 11 of the Partnership Act, which says that notwithstanding anything contained in section 27 of Indian Contract Act. That means notwithstanding anything means Indian Contract Act may be saying that you cannot have such contract, but still if you have a contract which says that a partner shall not carry on any business other than that of the firm while he is a partner, then this kind of a contract shall be a valid contract and we will not treat it as a void contract. Okay, these kinds of contracts are valid contract because if he is allowed to, if one partner of a firm is allowed to carry on his own independent business as well, then how will we expect him to devote time for the firm's business? Okay, so he will not be much serious with the firm's business, he will be serious with the his own business. So when you are a partner in a partnership firm, you must carry on only one business, that is the business of the partnership firm. Okay. Okay, such kind of contract shall be valid. This is the verdict of section 11. Section 11 provides that, subject to the provisions of Act, the mutual rights and duties of the partners of a firm may be determined by contract between the partners, and such contract may be expressed or may be implied by a course of dealing. It further provides that such contract may be varied by consent of all partners. Section 11.2 clearly provides that, notwithstanding anything contained in Section 27 of the Indian Contract Act, the contract between the partners may provide that a partner shall not carry on any business other than that of the firm while he is a partner, and it shall be a valid contract. Okay. Partnership is a relation eminently depending on the consent of the parties. Okay, because partnership is a very closed unit, okay, in which 4 or 5 people come together. So a lot of thing in a partnership depends on the consent of the partners. Okay, so whatever happens with the consent of partners. It is not a kind of a company in which there are 1,000 shareholders and only 4 or 5 board of director members sit and make decisions. No, here decisions are happening by all the parties interested. 3 4 people, they sit together and take decisions for themselves, not only for its existence but for the terms of the agreement in all things consistent with its essential nature and purpose. And an agreement to become partner in the first instance or to vary the terms at any time need not be manifested in any particular form. Okay, need not be manifested in any particular form. That means it may be in writing, or it may be oral, or it may be implied, or it may be by conduct, it may be by any way. It is not mandatory that you write it down, because it depends upon your interpersonal relations. Okay, if you have faith between yourself, you cannot write it. If you do not have faith between yourself, you write it down. It is like this. The conduct of the business, section 12. Subject to contract between the partners. Every partner has a right to take part in the conduct of business. Now, whatever these are the general rights of partners to carry on the business of partnership firm. But before these rights are written down here, the opening words are subject to the contract between partners. That means if by contract you have removed this right, that every partner has a right to take part in the conduct of business. If you have taken out, striked out this right, then that means the every partner shall not have that right. Okay, these are general rights which, if you do not have a contract, then every partner shall have it. But if you have a contract, then these rights can be enlarged or can be curtailed as well. Okay, now let us read the rights of the partners in the conduct of business. Every partner has a right to take part in the conduct of business. Definitely, every partner is bound to attend diligently to his duties in the conduct of his business. Okay, now we have heard some term in earlier lecture, that a sleeping partner or partner in profits only. So the partner in profit will not take part in the conduct of business. Sleeping partner is not bound to attend diligently to his duties. Okay, that means by contract you can strike out these rights as well. But if you do not do so, then all partners will automatically have these rights, because the section 12 says so. Any difference arising as to the ordinary matters connected with the business may be decided by majority of partners. Like we'll have a voting. If there is a dispute, the majority of partners will be winning. And every partner shall have the right to express his opinion. You cannot shut down any partner, okay? Simply because you people are in majority, that does not mean you will not allow him to say. Every partner in a partnership has right to express his opinion before the matter is decided. Okay, and you have to hear him. You may be deciding against him, no issues, but let him at least speak. A reasonable time to speak must be given to him. But no change may be made in the nature of business without the consent of all partners. If you do not have any agreement, against this. If you say that we have a like a agreement in case of KT Kamath, if you have such kind of agreement in which you say the change in nature of business can be made by the managing partner and no authority from other partners is required, then that can be done. But if that is not the case, then business cannot be changed. Suppose you are in the cricket business, suppose you are in sports industry, you cannot go to the real estate sector without consent of all partners. Consent of all partners should be there. Every partner has a right to have access to and to inspect the copy of every partner has a right to have access to and to inspect and copy. That means he can get a photocopy as well, any of the books of firm. Now books of firm here means the business dealings, okay, accounts of the book, account book of the firm. Every partner can have access to the accounts or to the books of firm and even can get a photocopy of the same if required. Now, analysis of Section 12. Right to take part in conduct of the business. Section 12A. Every partner has the right to take part in the business of the firm. This is because partnership business is a business of partners and their management powers are generally coextensive. Coextensive means they are equal. All are equal to each other. None of them is superior or inferior. So every partner has a right because all are equal. So everyone shall have a equal power and equal right to carry on the business of the firm. Now suppose this management power of the particular partner is interfered with and he has been wrongfully precluded from participating therein. Can the court interfere in these circumstances? The answer is an affirmative. Affirmative means yes. Okay, because you are trying to interfere wrongfully. The word is wrongfully. We are not saying by contractually. Contractually, you can preclude. Contractually, we can preclude. Okay, but not wrongfully. If something like this happens, he can approach the court. The court can and will. The court has power, and court will. And will means court will definitely exercise its power. By injunction, injunction means court will direct them to restrain other partners from doing so. Court will restrain partners from doing so that you do not interfere in his right. Allow him to enjoy his privileges as a partner. It may be noted in this contention that a partner who has been wrongfully deprived of the right of the participation in the management has also other remedies like suit for dissolution, a suit for accounts without seeking dissolution. Now he has some other rights as well. Now he can seek a suit for dissolution that this firm should be dissolved. Okay, or he can seek a suit for accounts without seeking dissolution that I do not seek dissolution of the firm but accounts should be shown to me. These are the remedies provided to him by the court and the act as well. The above mentioned provisions of law will be applicable only if there is no contract to the contrary between the parties. Like I discussed, contractually one partner could be prevented from taking part in the business of the firm. This is again the explanation. The above mentioned provisions of law will be applicable only if there is no contract to the contrary between the partners. It is quite common to find a term in partnership agreements which gives only limited powers of management to a partner, or a term that the management of the partnership will remain with one or more of the partners to the exclusion of others. We usually call them managing partners. Usually, contracts are such that XYZ will be managing partner and he will do this and that, like in the case of KT Kamath, we discussed the brief facts. In such a case, the court will normally be unwilling to interpose with the management with such partner or partners unless in such cases court will usually not interfere unless it is clearly made out that something was done illegally or in breach of the trust reposed in such partners. Unless you make out a case in front of court that what they are doing illegal, and they are doing with malicious intentions, okay, then court can jump in. Otherwise court would usually not jump in between partners when there is a contract, because courts are put in place in order to honor the contractual obligations between the parties. The only ultimate job of the court is to honor the contractual obligations between the parties. Court cannot put their own opinions unnecessarily between a firm when the contract is going on, okay. Right to be consulted, Section 12C. Where any difference arises between the partners with regard to the business of the firm, it shall be determined by the views of majority of them, and every partner shall have right to express his opinion before the matter is decided. This is the brief of crux of right to be consulted, that you must consult other partners, and even if you have to decide, even if the other partners are deciding something against the, suppose there are five partners, four are on one side, one is on the other side, then he has a right to be consulted. He can ask you questions, you have to give him answers, and he can express his opinion, you have to listen him. It is not that simply because you are four in number you will just shut down his mouth. No, you cannot do that. So, but no change in the nature of business of the firm can be made without the consent of all the partners. Okay, so whatever you do, okay, you can take decisions regarding business by majority, but if there is a decision regarding change of the business, like from sports industry to the real estate, from real estate to the Bollywood, from Bollywood to the artwork, you cannot do so without the consent of all the parties. That means unanimous. Unanimous means 100%. Unanimous consent is required for bringing the nature of business, for bringing change in the nature of the business. Okay, this means that in routine matters the opinion of the majority of partners will prevail. Of course the majority must act in good faith, and every partner must be consulted as far as practical. It may be mentioned that the aforesaid majority rule will not apply when there is a change in the nature of firm itself. In such a case, the unanimous consent of partners is needed. Okay, the majority the majority rule shall not be applicable in such a case when you are trying to change the nature of business. Okay, in single shot. Right of access to books. Every partner, whether active or sleeping, is entitled to have access to any of the books of the firm and to inspect and take out copy thereof. The rights must, however, be exercised bona fide. Okay, bona fide means this right. This right must be exercised fairly and reasonably. It is not that for every second week you will seek the books of account, you will take photocopies, and you will A partner is not entitled to share the books of accounts with other general public. It does not mean that you have a right to take a copy of the books of accounts. It does not mean that you will take the copy and you will distribute the copies to other people who are not associated with the firms. Okay, so you can inspect, you can take the copy for your purposes and you can keep it with yourself, but that does not mean you will put the copy on your Facebook page or Instagram stories. Okay, so you have to exercise it in bona fide manner, otherwise this right too can be curtailed. You may be denied books of accounts, access to the books of accounts very validly. Okay. Mutual rights and liabilities. Subject to contract between partners. Now, what are mutual rights and liabilities between partners? Now, every section begins with words like subject to contract between partners. What does it mean? It means ultimately, if you have a contract, the contract, the provisions of the contract, what you people have decided into say, will prevail over the provisions of Indian Partnership Act. Okay. So your contract is more powerful than the provisions of the Indian Partnership Act. Why? Because in order to provide, law has allowed this much space to partnership and partners in order to facilitate the smooth and flexible functioning of the partnership so that there is no unnecessary restriction in the partnership. A partner is not entitled to receive remuneration for taking part in the conduct of business. Okay, so usually a partner is not entitled to salary. Under normal circumstances, a partner is not entitled to receive a salary or remuneration for conducting the business of partnership. But by contract, if you people have a contract, agree, then salary may be provided. Usually, there is no salary and only profits are to be shared. Okay, only thing which is to be shared and which this partner is entitled to is share of the profits. That's it, not salary. The partners are entitled to share equally in the profits earned and shall contribute equally to the losses sustained by the firm. That partners are entitled to share equally, okay, but this usually does not have, the share is always changing depending upon the contribution. When a partnership come into picture, all people pool in their assets. Okay, like four partners are there. Someone will put some money, someone will put some money. Now, however money, it depends upon the amount of capital contribution. Capital contribution means in amount of money and assets you have brought in at the time of partnership, your share will be divided on that thing. Okay, so you will share the, otherwise you will share the profits equally as well as contribute the losses equally. Okay. Where a partner is entitled to interest on the capital subscribed by him, such interest shall be payable only out of the profits. Okay, sometimes there may be a case that Okay, so this is a normal rule, but you can have a rule otherwise as well. Normal rule is sorry, excuse me. A, B, C, and D enter into a partnership. Each of them put 25 lakh rupees each. Okay. Now, after some time, the partnership required another 50 lakhs rupees. A said, I will pay 50 lakh rupees to the partnership, but will take 12% interest. Okay. Then normal rule is such interest shall be payable only out of profits. That means That means if firm is not making any profit, firm is running into losses, then no interest shall be payable to this partner for his capital contribution. Okay, excess capital contribution. But it can be changed by a contract. It depends upon the contract. We'll take a 2 minutes break here, please. Meanwhile, you read the other duties. A partner making for the purpose of business and a payment in advance beyond the amount of capital he has agreed to subscribe is entitled to interest thereon at the rate of 6% per annum. Okay, so if he has done anything excess like in this case, then usually his rate of interest is going to be 6%. But it could be 12, 18, or 24 depending upon the mutual understanding between the partners. If partners agree to pay a higher return or higher rate of interest, no one can deny it. Court can never enter into it. And the usual rule is that same shall be paid only out of the profits. The firm shall indemnify a partner in respect of payments made and liabilities incurred by him in the ordinary and proper conduct of business. Okay. If in the ordinary course of business, now what happens? A, B, C, D. They are four partners in a firm which is selling sugars, which is trading in sugar. He goes to Maharashtra, A is partner. He goes to Maharashtra for some work but finds an opportunity to buy sugar at a cheap rate. So when he is buying a sugar for the cheap rate, definitely they will sell it at a higher margin and the firm will make a profit. But he has to make the payment there only at the spot. Okay, otherwise sugar will be sold to someone else. He does not have much time to consult to the other partners or to take money from the firm's account. He pays out of his own pocket, okay, and buys the sugar and gives it to the firm. Then in such case, that is the ordinary and proper conduct of business. In such case, the firm shall indemnify a partner in respect of payments made and liabilities incurred by him. So he has made a payment there, okay, or he may incur a liability as well sometimes here, okay. So whatever he'll do for the firm in the ordinary and proper conduct of business, firm shall indemnify him. Now that means whatever he has paid, firm shall pay back him after deducting his share of contribution, okay. In doing such act in an emergency, like this is an emergency situation we discussed, for the purpose of protecting the firm from loss, as would be done by a person of ordinary prudence in his own case under similar circumstances. And that means if in some emergency situation, suppose now they are sugar selling, okay, they have firm has 2 tons of sugar in go down, okay, and one partner immediately comes to a knowledge that prices of sugar are going to fall, okay, very heavily. He immediately sells them, immediately sells sugar in market in order to prevent losses. Now in such cases, firm cannot have any liability upon him. Firm will have to compensate him if some loss he has suffered due to preventing loss for the firm, or in case he has incurred some personal liability. A partner shall indemnify the firm for any loss caused to it by his willful neglect in the conduct of business. Now we are not talking about neglect, we are talking about willful neglect. That means he did it by knowing that my act is going to be bad for the firm. If then also he does it, that is just like a case of fraud we discussed. Similar is the case of willful neglect. If a partner has done something negligent, willfully has done something like suppose he left the sugar openly without covering in monsoon season and it rained and sugar is destroyed. Now this partner, because he is responsible for doing this, He must indemnify the firm for his willful neglect in the conduct of business. Analysis of section 13. We will quickly read it because we have already done the discussion. No partner is entitled to receive any remuneration in addition to his share in the profits of the firm for taking part in the business of the firm. But this rule can always be varied by an express agreement or by a course of dealings, in which event the partner will be entitled to remuneration. If you have a contract, he can have a remuneration. Thus, a partner can claim remuneration even in the absence of a contract when such remuneration is payable under continued usage of firm. In other words, where it is customary to pay remuneration to a partner for conducting the business of firm, he can claim it even in the absence of contract for the payment of same. Usage of firm is doing this. It's a tradition at the firm. Like one partner is traveling to Sri Lanka for some business purpose, and it's a usage that when partner travels for work, the company pays for his travel plus hotel plus food, okay, and all the expenses he has made there for business. So the firm pays him that expenses. So that is a usage of the firm. So tomorrow, if another partner travels to USA for business and he incurs a liability of 5 lakh rupees there in going coming back staying there meeting people, he has spent 5 lakh rupees and firm says we will not pay you. Why should we pay you and we do not have a contract for that? Then he can bring his case in the usage of the firm thing, that this firm has constantly paid to all the partners who have traveled. So when I have traveled, why they are not paying me? Okay, even if there is no contract here, but this is the usage of the firm, so he can claim that from the firm. Right to share profits. Partners are entitled to share equally in the profits earned and so contribute equally to the losses sustained by firm. The amount of a partner's share must be ascertained by inquiring whether there is an agreement in that behalf between the partners. If there is no agreement, then you should make a presumption of equality. If there is no agreement, then we will presume that shares are to be distributed equally. And the burden of proving that the shares are unequal will lie on the party alleging the same. And the burden of proof will be on the partner who is trying to say that I will take the more share. There is no contract, but I'll take 80% share. Then he'll have to prove that why he will take 80% share. Okay. There is no connection between the proportion in which the partners shall share the profits and the proportion in which they have contributed towards the capital of the firm. There is no connection in this thing. How much money you paid, okay, initially, how much money you brought to the firm, you would equally share the profits unless there is some contract, okay. Interest on capital. The following elements must be there before a partner can be entitled to interest on monies brought by him in the partnership business. An express agreement to that effect or practice of the particular partnership. Okay, either there should be an agreement, written agreement, or usage of trade, like we discussed. Practice of the partnership firm is the usage of partnership firm. Any trade custom to that effect. Okay, if there is any customary trade in that particular community of partnership, that all partnerships do so, and a statutory provisions which entitles him to such interest. If there is any statutory provision which says that he should take interest, then he will be given interest. Interest on advances, section 13d. Suppose a partner makes an advance to the firm in addition to the amount of capital to be contributed by him. In such a case, the partner is entitled to claim interest thereon at 6% per annum, while
It's
interest
9
on
o'clock.
capital account ceases to run on dissolution. The interest on advances keep running even after dissolution and up to the date of payment. Okay. While interest on capital ceases to run on dissolution, but the interest on advances means interest on capital means initially each bring a capital. Okay, each people bring a capital. Each partner will say let's contribute 25 lakh each. Okay, interest on capital is that. Interest on advances if you have given a loan. Interest on advance means a loan given to the firm. Okay. Right to be indemnified. Section 13E. Every partner has the right to be indemnified by the firm in respect of payments made and liabilities incurred by him in ordinary and proper conduct of the business of the firm, as well as in the performance of an act in an emergency for protecting the firm from any loss, if the payments, liability, and act are such as prudent man would make, incur, or perform in his own case under similar circumstances. Okay, so if in emergency he has suffered some loss for the firm, to avoid, sorry, he has suffered some personal loss in order to avoid loss to the firm, then firm shall pay him. But what kind of the conduct should be there? Conduct should be as a prudent man would make, like as a man would make, like suppose if I am in that position or any reasonable man in that position, and he would also do that. Okay, any man would have done that what he has done. He has not done something exceptional, but he has simply done what any other prudent businessman would have done in such a situation, and he has taken a liability. Then the firm has to indemnify him. Right to indemnify the firm. A partner must indemnify the firm for any loss caused to it by willful neglect in the conduct of business of the firm. This is basically, we should call it a duty. This is a duty, not right. And if we call it right, then it should be right of the firm to be indemnified. Okay, right of the firm to be indemnified. Either it is duty to indemnify the firm, or if we use it in the word of right, we should say firm's right to be indemnified. Okay, firm's right to be indemnified. So when he is causing a willful loss, like in the case of we discussed, he has left the sugar openly without covering in monsoon season and it rained. So in such a case, if losses occur to the firm, he must make it good. Sorry. Now we will discuss partnership property. That is section 14. What is the property of partnership? Okay. Property of the firm, section 14. Subject to the contract between the partners, the property of the firm includes all subject to the contract between the partners. Okay, if there is a contract which says otherwise, then we will go by the contract. If there is no contract, we will go by the section. Okay, subject to the contract means if there is a contract, we will go by the contract. If there is no contract, then we will go by the section. So section is secondary. Okay, section is when nothing is there. When something is there, some agreement is there, then we will look into the agreement and we will avoid the section. Okay, please read it. Subject to the contract between the partners, the property of the firm includes all property and rights and interest in the property originally brought into the stock of the firm. Okay, the property of the what is the property of the firm? The property of the firm it includes following: one, all property and rights and interest in the property originally brought into the stock of firm. Okay. Originally brought into the firm means when the firm started, when the firm inception, when the firm was born. Okay, at that time, whatever was the property brought to the firm. Okay, the firm shall have all the rights and interest. Okay, in such property. Second, or acquired by purchase or otherwise, or acquired by purchase or otherwise. Otherwise, maybe a business deal in which you may have somebody had to pay you something, but he could not pay you, so he gave you a property. Okay, okay. Property acquired by purchase or otherwise, by or for the firm, by the firm or for the firm, or for the purposes and in the course of the business of the firm, and includes also the goodwill of the business. Also, the goodwill of the business. Now, what is goodwill? It's a very complex term. Okay, it has different meanings and it has different connotations. But simply, I will give you a very simple, clear example, and you will understand it. Haldiram, we have North India. Haldiram, a snacks joint, or you can say Sarvana Bhava, Sarvana Bhava in Tamil Nadu. This brand, Sarvana Bhava, or Haldiram, or Reliance, Tata. Okay, these brands automatically have some power in them because of their popularity, because of their usage, because of their antiquity, okay, or because of their net worth or their quality, their customer satisfaction, whatever you call it, Amazon, okay, they are brands. So, whatever they do, they are considered credible and good. So, they are brands. So, this Reliance, this name Reliance, has a goodwill. Tata has a goodwill. Amazon has a goodwill. Sarvana Bhav has a goodwill. Haldiram has a goodwill. So tomorrow, if I set up a restaurant and call it a Sarvana Bhav, automatically any Tamilian living in Delhi, if he comes to my restaurant, he'll see Sarvana Bhav. He'll feel that this is the branch of Sarvana Bhav of Tamil Nadu, and he'll prefer my restaurant than other restaurants in Delhi because he'll feel that I will get the taste of my own place in Delhi. That is a goodwill. Okay. So, firm owns this brand as well. This brand name is owned by the firm. Property originally brought by the firm, plus which is later on purchased or acquired by the firm, also the goodwill of the firm becomes the property of the firm. This is the property of the firm. Unless the contrary intention appears, property and rights and interest in the property acquired with money belonging to the firm are deemed to have been acquired for the firm. Okay, so whatever is purchased from the firm's money. From a pencil to aeroplane, whatever is purchased with the firm's money will become the property of firm. Okay. The expression property of the firm, also referred to as partnership property, partnership assets, joint stock, common stock, joint estate. These are some of the other names of partnership property. Denotes all property, rights, and interest to which the firm, that is, all partners collectively, firm is all partners collectively, may be entitled. The property which is deemed as belonging to the firm in the absence of any agreement between the partners showing contrary intention is comprised of the following items. All property, rights, and interest which partners may have brought into the common stock as their contribution to the common business. All property, rights, and interest acquired or purchased by or for the firm or for the purpose and in the course of the business for the firm. Goodwill of the business. The determination of question whether a particular property is or is not property of firm ultimately depends on the real intention or the agreement of partners. Thus, the mere fact that the property of a partner is being used for the purpose of the firm shall not by itself make it partnership property. Okay, because the mere fact that the property of a partner, suppose I am a partner and I have a spare shop with me, I let the partnership use that shop as a business office for the firm. It will not automatically become the firm's property. Okay, it is my property. I, as a concession, because I am also a partner, I allow so that so as the firm is not bound to pay rent somewhere. Okay, I allow firm to use my commercial property for firm's business. It does not mean that this property will automatically become a firm's property. No, it is my own property. Unless it is my intention to make it a firm's property. Thus, the mere fact that the property of a partner is being used for the purposes of the firm shall not by itself make it a partnership property unless it is intended to be treated as such. I have a car. The car is being used for the firm. That does not mean the car will become firm's property. But if there is an intention to transform this car as a firm's property, and I have taken share, I have taken money from the other partners for getting this car as a firm's car, then the car will become a firm's property. Okay, unless it is intended to be treated as such. Partners may, by an agreement at any time, convert the property of any partner or partners, and such conversion, if made in good faith, would be effectual between the partners and against the creditors of the firm, or the separate property of any partner into a partnership property. Okay, partner can convert partner's property, okay, into partnership property anytime by a contract. Goodwill. Section 14 specifically lays down that the goodwill of a business is subject to a contract between the partners to be regarded as property of the firm. But this section does not define the term goodwill. Okay, this section does not define the term goodwill. But I have just given you an explanation of what a goodwill is. Goodwill is a accounting term. It is a much complex term. So many scholars have given this a different kind of explanation, but the ultimate explanation is what we are trying to deal here with this example. This is the goodwill. Goodwill is a concept which is very easy to understand but difficult to define. Like it discussed, like I said, easy to understand but difficult to define a complex situation. Goodwill may be defined as the value of the reputation of a business house in respect of profits expected in future over and above the normal level of profits earned by undertaking belonging to the same class of business. Okay, so when Ambani is also in petrochemicals, Reliance is in petrochemicals, I also set up Shaker Petrochemicals. So definitely my petrochemical will have less profit margin than Reliance's. Reliance will have higher profit in the future as well. That is the goodwill. When a partnership firm is dissolved, every partner has a right, in the absence of an agreement to the contrary, to have the goodwill of the business sold for the benefit of partners. If there is no such contract, then every partner has a right to sell the goodwill of the business for the benefit of partners. Okay. If he has sold the goodwill of business, goodwill of the firm for 1 crore rupees, then he must distribute this 1 crore rupees between all partners. He cannot say, I'll keep all those 1 crore rupees. Okay. Goodwill is a part of the property of the firm. It can be sold separately or along with other properties of the firm. Any partner may, upon the sale of goodwill of the firm, make an agreement with the buyer that such partner will not carry on any business similar to that of the firm within the specified period or within specified local limits, and notwithstanding anything contained in section 27 of Indian Contract Act, such agreement shall be valid if the restrictions imposed are reasonable. That means after sale of your brand. Sale of brand. Suppose let us say Tamil brand, we say Sarvanabhav. Its owner has sold it to another Tamilian people. Okay. Its owner has sold it to some other person. Now Sarvanabhav brand sold to X, another Tamilian. Okay. Now X can have an agreement that the firm shall not enter into food business food business within state of Tamil Nadu, Karnataka, Andhra Pradesh and Kerala, because these four places are where this Savanabhava is very popular. Okay, and that would be reasonable. That would not be understood to be a void agreement as per the Indian Contract Act. It will be a reasonable agreement. But if he says no food business in whole India, that shall be unreasonable. Okay, because Savana Bhav is popular in South India, so you cannot even stop them from doing something in Gujarat. But yes, if some brand is popular in India, overall India, then you can stop them from doing business in India itself. But in food industry, if they want to manufacture clothes, you cannot stop them from manufacturing clothes. Okay, you cannot stop them from working all together in any place of India or any place of world. Okay, you can stop them from entering into the similar kind of business. If they have sold your restaurant, they cannot run a restaurant, but they can definitely have a cafe. Okay, they can definitely have processed food industry. They can have juices industry. They can have cola industry. They can have anything, but they should not. They cannot have a similar kind of South Indian style restaurant running parallel to Sarvanabhav. No, they cannot do so, and that will be reasonable. Property of a partner. Where the property is exclusively belonging to a person, it does not become a property of partnership merely because it is used for the business of partnership. Such property will become property of the partnership if there is an agreement. Okay, if there is an agreement, then the property of partner will become the property of partnership, but automatically that will not happen. It is not that I have property worth rupees 2 crore, I set up a partnership and automatically my 2 crore rupees of assets now become the property of partnership. Okay, no, that will not happen. Application of the property of the firm, section 15. Application means use. Subject to the contract between the partners, the property of the firm shall be held and used by the partners exclusively for the purpose of the subject to the contract. If there is a contract, contract shall prevail. Otherwise, this provision. The property of the firm shall be held and used by the partners exclusively for the purpose of the business. Okay, exclusively for the purpose of business and no other business at all, no personal use. Okay, no personal use. Analysis of section 15. Section 15 provides that the property of firm shall be held and used exclusively for the purpose of the firm. In a partnership, there is community of interest, which all the partners take in the property of firm. But that does not mean that during the subsistence of the partnership, a particular partner has any proprietary interest in the assets of the firm. Every partner of the firm has a right to get his share of the profits till the firm subsists, and he also has a right to see that all the assets of the partnership are applied to and used for the purpose of partnership business. Shekhar is me here. Okay, A, B, C, D, and I, Shekhar. We five people set up a firm for suppose import and export of onion. Okay, we have a large office area in commercial street. But right now, suppose government has banned the import and export of onions. Okay, for 6 months there is a ban on import and export of onions. That means for 6 months, firm is doing no business at all, isn't it? But we have a big office area in a commercial street. And Shekhar, I am a lawyer. So I start providing law coaching in the office of firm for 6 months. Okay. Because the firm is ultimately doing no business, so office is vacant. So I start teaching students. Some 200 students come and I provide them coaching and I am making profit. This is not valid. Okay, this is not valid. Firm's property has to be used exclusively for the purpose of the business, and the purpose of the business is onions only. That's it. Purpose of the business is not law coaching. It is only onions, nothing else. Personal profit earned by partners. Section 16. According to Section 16, subject to the contract between partners. If a partner derives any profit for himself from any transaction of the firm, or from the use of property or business connection of the firm name, he shall account for that profit and pay it to the firm. Now, personal profit has been made. Let's read it again slowly. If a partner derives any profit for himself from any transaction of the firm, or from the use of the property or business connection of the firm or firm name, he shall account for that profit and pay it to the firm. Now, I have used the property of the firm for my personal business and I have gained, suppose, say, I have earned 20 lakhs for this coaching. I must put this 20 lakhs in the account of the firm and it shall be distributed between all the partners as a profit. I cannot take home this whole 20 lakhs with myself. Okay. Or business connection of the firm. Let us deal another example as well. I am a managing partner of firm. Okay, of a law firm, suppose law firm. My law firm, I have been selected, awarded as best lawyer in country by Bar Council and 50 lakh cash prize is given to me. Now this 50 lakh rupees, I can keep the designation of best lawyer in the country to myself. But this 50 lakh rupees, I'll have to put into the firm's account. Okay, 50 lakhs must be put into firm's account and used accordingly by firm. And if I do not do so, suppose I keep my price. If I do not do so, then firm can file a case against me and get it done through court. Okay, then firm can get it done through court if I do not do it myself. If a partner carries on any business of the same nature as and competing with that of the firm. He shall account for and pay to the firm all profits made by him in that business. I am a partner of a law firm. Okay, but I have my independent law practice as well. Because the my firm is also doing law practice, and I am also starting my own law practice independently. So I am earning profits from here as well, and I am making profit here as well. So usually, what should be the case? I should be working for the firm. In whatever cases I have, I should take these to the firm. My firm should have all the cases because I am doing the same nature business. Okay, then in that case, whatever profit I make as an independent lawyer, independent practice, I should give it back to the firm, and firm shall distribute it accordingly, like in this case. But if I am providing, if I am selling sugar as well, I am a sugar dealer independently, and I am a partner of the law firm. Then this is not a competing business. They are not of same nature. Law practice and selling sugar are not of same nature. So when I make a profit in this way, then the firm is not entitled to this profit. Okay? Because I am not competing in the same business. I am doing some other business, and when I am doing that, the firm is not entitled to take my profits because just because I am a partner of the firm. No. This is my own independent business separate from the partnership firm. Where a partner derives any profit for himself from any transaction of the firm, or from the use of the property or business connection of the firm or firm name, he must account for that profit and pay it to the firm. Let's do an example given by the section, given by the book. A, B, C, and D established partnership business for refining sugar. A, who was himself a wholesale grocer, was entrusted with the work of selection and purchase of sugar. As a wholesale grocer, A was well aware of the variations in the sugar market and had the suitable sense of propriety as regards purchase of sugar. He had already in stock sugar purchased at low price which he sold to the firm when it was in need of some, without informing the partners that the sugar sold had belonged to him. It was held that A was bound to account to the firm for the profits so made by him. This rule, however, is subject to a contract between partners. Okay, so he himself had some sugar. Okay, and the firm was also into sugar. So firm wanted some sugar. He sold his own sugar to the firm and made some profit. This he should not have done. Now, whatever profit he has made, he should give it back to the firm. Okay. Where a partner carries on a competing business, he must account for and pay to the firm all profits made by him in such business, like we have discussed here in this case. A, B, C, and D started a business in partnership for importing salt from foreign ports and selling it at Chittagong. A struck certain transactions in salt on his own account, which were found to be of same nature as the business carried on by the partnership. It was held that A was liable to account to the firm for profits of the business so made by him. This rule is also subject to contract between the parties. Okay. So the firm was into salt. So while working with the firm, A got a good knowledge of the salt. So what he did, he independently did a transaction of the salt and made profit. Then this profit belongs to firm because from firm he has taken this knowledge and he is working for the firm. And if we allow partners to set up independent competing business, then who will work for the firm? Everyone will start making their own personal profits. Nobody will work for the firm, and firm is a collective venture and it's a duty. When we did the duties of the partners, the duty was greatest common good or greatest common advantage of the firm. That's it. This is the duty of the partner, that whatever he should do it for the greatest common advantage of the firm. Rights and duties of partners after change in the firm. Now, what are the rights and duties of partners when there is a change in the firm? Let us do it. According to section 17, subject to contract between partners. Now, every section is beginning with subject to contract between partners, so I will not stress it again and again. The main issue is if you people have a contract, then contract shall prevail. If you do not have a contract, then provisions of section shall come into picture. Otherwise, section shall be avoided and contract shall be uplifted, upheld. After a change in the firm. Situation A. Where change occurs in the constitution of the firm. Constitution means change of the partners. Number of partners there were 3, now there are 30. Okay, or the constitution is some managing partner is changed, or firm was for sugar, now it is for salt, or now it is for real estate, now it is for banking, like this. Where a change occurs in the constitution of a firm, the mutual rights and duties of the partners in the reconstituted firm remain the same as they were immediately before the change, as far as may be. Okay, it was earlier a sugar selling firm, now we are selling cricket bats. But our profit sharing ratio and all duties and whatever our role is shall remain same unless it is changed by an agreement. Okay, shall remain same unless changed by an agreement subsequently. After the expiry of the term of the firm. Where a firm constituted for a fixed term continues to carry on business after the expiry of that term, the mutual rights and duties of the partners remain the same as they were. Okay, where a firm constituted for a fixed term continues to carry on business after the expiry of that term. Like we discussed, there were fixed terms, fixed firms, okay, which came fixed partnerships for a fixed period of time. Okay, fixed term continues to carry on business. Now it will become a partnership at will. Okay, so now after the expiry of that term, the mutual rights and duties of partner remain the same as they were before the expiry, so far as they may be consistent with the incidents of the partnership at will. So now the fixed partnership has turned into a partnership at will, but it says that duties and rights of the partners shall remain same as they were earlier before the expiry of the fixed period. Where additional undertakings are carried out. Where a firm constituted to carry out one or more adventures or undertakings carries out other adventures or undertakings are the same as those in respect of original undertaking. That means their duties and liabilities shall remain same as they were same in the original undertakings. Now you were trying to make a bullet train, but now you are trying to make a build a housing society for poor. But your liabilities and rights shall remain as far as possible same as they were earlier. Relation of partners to third parties. We'll take a 1 to 2 minutes break here. You read it and I'll be back with you people. Relation of partners to third parties. Partner to be agent of the firm. Okay. Subject to the provisions of this act, a partner is agent of the firm for the purpose of the business of the firm. Okay. Like we discussed that there is an element of agency between firm and the partner. You may recall that a partnership is the relationship between the partners who have agreed to share the profits of the business carried on by all or any one of them acting. Section 4. This definition suggests that any of the partner can be the agent of the others. Section 18 clarifies this position by providing that, subject to the provisions of the Act, a partner is the agent of the firm for the purpose of the business of the firm. Okay, that means the partner indeed virtually embraces the character of both a principal and an agent. A partner is a principal as well as an agent as well. Okay, he takes the character of both people, both the persons. So far as he acts for himself and in his own interest in the common concern of the partnership, he may properly be deemed a principal. And so far as he acts for his partners, he may be properly deemed as an agent. Okay, when he is acting for himself, then he will be a principal. When he is acting for others, when he is acting on the behalf of other partners, it will be he will be a agent. So he has a dual personality. He is principal as well as agent. The principal distinction between him and a mere agent is that he has a community of interest with other partners in the whole property and business and liabilities of partnership, whereas an agent as such has no interest in either. The only difference they say is that agent has no interest. Usually an agent has no interest. He is just an agent. But here they say when he is a partner has interest in the firm. Okay. The rule that a partner is the agent of the firm for the purpose of the business of the firm cannot be applied to all transactions and dealings between the partners themselves. It is applicable only to the act done by partners for the purpose of business of the firm. It is not that whatever they are doing in their personal life and whatever dealing they are having with some other people or with the partners, they will always be binding the firm. No, when they are working for the firm, then only they are deemed to have bound the firm. Okay, so they are relations. We are now doing relations of the partners to third parties. Okay, what are the relations of partners to third party? Partner to be an agent of the firm. Okay. Implied authority of a partner as agent of the firm. Okay. Subject to provisions of Section 22, the act of a partner which is done to carry on in the usual way business of the kind carried on by the firm binds the firm. Okay. Implied authority of the partner as agent of the firm, that he will bind the firm when he is carrying on the business of the firm. The authority of a partner to bind the firm conferred by this section is called implied authority. Now, this is something else. Firm is in sugar business. Partner is also having his own separate sugar business. So, whatever this person, this partner is dealing in his own sugar business will bind the firm as well. Okay, it will impliedly bind the firm as well. Though right now he is not acting for sugar business of the firm, he is acting for his own sugar business. But because he is the partner of the firm, his actions here will bind the firm there because they are all in the same business. Okay. In the absence of any usage or custom or trade to the contrary, the implied authority of a partner does not empower him to. Now, the restrictions on the implied authority of the partner. He is not entitled to just simply understand what a partner is not entitled to do. Submit a dispute relating to the business of the firm to arbitration. Arbitration is just like a court but not a court. Okay. A dispute. Okay, it's a dispute mechanism body which settles the dispute outside the court. Usually, retired judges sit here. Okay, so you can submit your commercial dispute to arbitration as well, and whatever then the arbitration tribunal will decide will be final. So, a partner cannot submit the dispute of a business of the firm to arbitration. Partner has no such authority. He'll have to take consent of others, and the firm shall decide. Open a banking account on behalf of the firm in his own name. This he cannot do. A partner cannot set up a bank account for the firm in his own name. Okay. The bank account of the firm shall be set up in the firm's name alone. He cannot have it in his own individual name. This is not what he could do. Compromise or relinquish any claim or portion of the claim by firm. Compromise means settle. Relinquish means leave or forego. Any claim or portion of claim by the firm. Any claim or portion of claim means firm says that XYZ have to pay 40 lakh to firm. An individual partner of the firm cannot go and say that I reduce it to 20 lakh, that I relinquish 20 lakhs. Okay, or I settle the dispute. You give me 10 lakh and now you don't have to pay anything to me. Or you give me a piece of plot and you do not have to pay 40 lakh. Or you don't have to pay 40 lakh, you just have to pay 30 lakh. A partner cannot do so. It's a collective decision by the firm and firm shall take. Even if the partner is doing so shall be illegal by the partner. withdraw a suit or proceedings filed on behalf of the firm. Okay, there is a case or proceeding in the court of law which which firm has to file. Okay, he alone cannot file it in his own name. Okay, on behalf of firm, he cannot do so. He cannot withdraw it. There is a suit pending, case going on. He cannot go to the court and say that we wish to withdraw the case, we do not want to proceed with the case. No, firm can do so, he cannot do so. Admit any liability in a suit or proceeding against the firm. XYZ says firm has to pay 40 lakh rupees to them. An individual when and the firm says there's a dispute between XYZ and its firm. XYZ says firm has to pay 40 lakhs. Okay. And the firm says we do not owe you anything. And there is a court case. He cannot go into the court and say no, firm has to pay 40 lakhs. I as a partner, I say that firm has to pay 40 lakhs. He cannot do so. Okay. Acquire immovable property on the behalf of the firm. He cannot go on and purchase real estate business or immovable property like flat or plot or house or office commercial property for the firm on behalf of the firm. He cannot do so. Doing that will be illegal. Transfer immovable property belonging to the firm, or he cannot sell the property belonging to the firm. Only immovable property, that means he can sell the movable property. The restriction is restriction on implied authority is only for immovable property. That means partner can buy and sell as well movable property for firm. Okay, and what is a movable property? When we did Sale of Goods Act, we discussed any property which is movable and which is not attached to land. Okay, which is not permanently attached to land, it becomes a movable property or a good. Okay, so that means a partner can definitely validly sell or purchase goods or movable property for the firm. Like aeroplane also he can do so, ship also, but he cannot sell or purchase even an inch of land for the firm because it says immovable property cannot be done by him. Okay, enter into partnership on behalf of the firm. He cannot enter into further partnerships on behalf of the firm. He cannot make commitments with other partnerships on behalf of the firm. Mode of doing act to bind firm. Okay. In order to bind a firm, an act or instrument done or executed by a partner or other person on behalf of the firm shall be done or executed in the firm name or in any other manner expressing or implying an intention to bind the firm. So when a partner is trying to bind a firm, he should do so, okay, in the name of the firm only. Then only he can bind the firm, otherwise he cannot. Okay, this we are trying to analyze the section 19 and 22. At the very outset, you should understand what is meant by implied authority. First of all, you should understand what is meant by implied authority because we are discussing implied authority of a partner. You have just read that every partner is an agent of the firm for the purpose of business thereof. Consequently, therefore, as between the partners and the outside world, between the partners and the outside world means anyone outside the firm, whatever may be their private arrangements between themselves. Each partner is agent of every other in every matter connected with the partnership business. His acts bind the firm. Each partner is a agent of the firm, dealing with the while dealing with the outsiders. Okay, and whatever his acts in the usual course of business, he will bind the firm. Section 19 and 22 deal with the implied authority of a partner. The impact of these sections is that the act of a partner, which is done to carry on in the usual way, business of the kind carried on by the firm binds the firm, provided that the act is done in the firm name or any manner expressing or implying an intention to bind the firm. So when he is carrying his own independent business and he is a partner, partnership firm is also carrying the same business. Okay, then whatever he is doing in his independent business shall bind the firm as well. Okay, if he is sitting there acting as a partner. Okay, such an authority of a partner to bind the firm is called as implied authority. It is, however, subject to the following restrictions. The act done must relate to the usual business of the firm. That is, the act done by the partner must be within the scope of his authority and related to the normal business of the firm. So, whatever he is doing, it must be within the scope of his authority. He should not go beyond his authority. His act should not be ultra wires. Okay. The act is such as is done for the normal conduct of the business of the firm. The usual way of carrying on the business will depend on the nature and circumstances of each particular case. Case to case basis, suppose it's a share purchase and sale firm, so he is purchasing shares and selling shares. That is the usual course or firm, or he is purchasing and selling sugar. That is usual course for the firm is sugar selling, but he does what he does, he purchased onions and sold them. That is not the usual course of business for the firm. So when he does so, when he is purchasing onions, he is not binding the firm, because firm's usual course is sugar and he is into onions. Then what he is doing is personally, firm will not be bound. Okay, the act to be done in the name of the firm or in any other manner expressing or implying an intention to bind the firm. Okay, but when the firm is of sugar and he is also doing sugar business and he is doing with an intention to bind the firm, then the firm will be bound. Thus, a partner has implied authority to bind the firm by all acts done by him in all matters connected with the partnership business, and which are done in the usual way and are not in their nature beyond the scope of partnership. You must remember that an implied authority of a partner may differ in different kinds of business. Let's understand it with the help of an example. X, a partner in the firm of solicitors, borrows money and executes a promissory note in the name of firm without authority. Firm of solicitors means firm of lawyers. What he has done, he has borrowed some money. Now the firm is of solicitors, firm is of lawyers. Firm is not into borrowing or lending of the money. Firm is not a banking firm. Now he borrows money and executes a promissory note in the name of firm without authority. Now he has taken money from someone and executed a promissory note in the name of firm. The other partners are not liable on the note, as it is not the part of ordinary business of the solicitor to draw, accept, or endorse negotiable instruments. Because the solicitor is a lawyer, his normal work is appearing in the court and drafting of the legal agreements. His ordinary course is not to take loan or endorse something. Okay. However, it may be usual for one partner or firm of bankers to draw, accept, or endorse a bill of exchange on behalf of firm. Okay, but for banking firm he can do so. Okay, so for banking firm it may be usual activity, but for lawyers firm it will not be usual activity. So what is the usual activity will depend on case to case basis. Okay, this is the import of this section. If partnership be of general commercial nature, suppose if the partnership of general commercial nature means it does not have any fixed business. It does whatever it wants to. It is today it is selling sugar, tomorrow it will sell salt, tomorrow it will be banking, day after tomorrow it will be into the sports industry. That is a general commercial nature. Now in that general commercial nature, what he can do? He may pledge or sell the partnership property. Okay, he may pledge or sell the partnership property. He may buy goods on account of partnership. He may borrow money, contract debts, and pay debts on the account of the partnership. He may draw, make, sign, endorse, transfer, negotiate, and procure to be discounted promissory notes, bill of exchange, checks, and other negotiable papers in the name of the account of the partnership. So, when it is a general commercial nature, he can do whatever can be done because there is no fixed nature of the partnership here. Extension and restriction of the partner's implied authority. According to Section 20, the partners in a firm may, by contract between the partners, extend or restrict implied authority of any partners. Okay, partners may extend or restrict the implied authority of partners. Okay, notwithstanding any such restriction, any act done by a partner on behalf of the firm which falls within his implied authority binds the firm. Okay. Unless the person with whom he is dealing knows of the restriction or does not know or believe the partner to be a partner. So act of the partner will bind the firm, provided if the person he is dealing with knows that the partner has no authority, then in that case he will not bind the firm because the person dealing with the partner knows that this partner is acting beyond his authority. So when he is dealing with the partner, then he is dealing with the partner at his own risk, not at the risk of firm. Or he does not know that he is a partner of the firm. He is dealing with that person in the individual capacity. He is not dealing with him as a partner of some firm. Okay. The implied authority of a partner may be extended or restricted by contract between the partners. Under the following conditions, the restrictions imposed on implied authority of a partner by agreement shall be effective against third party. The third party knows about. So, if you have by agreement curtailed the implied authority of a partner, we are four partners. We curtail the implied authority of third partner. Okay, but that restriction shall be applicable only in those two cases. That third party knows about the restriction. Okay, if third party knows about the restriction on the partner, then the third party cannot rush against the firm later on. Or the third party does not know that he is dealing with a partner. That is also a kind of this is a doctrine of constructive notice, like we discussed in the company law, that this person knows that there is a restriction on this person, or doctrine of indoor management, that a person does not know whatever is happening between you people, it's 10 whether o'clock. You have restricted someone's authority or not. He is a partner for me. A partner borrows from B 1,000 rupees in the name of firm, but in excess of his authority, and utilizes the same in paying off the debts of the firm. Okay, he from over his excess authority he takes 1,000 rupees and uses same for paying off the debts of firm. Here the fact that the firm has contracted debts suggests that it is a trading firm, and as such it is within the implied authority of A to borrow money for the business of the firm. This implied authority, as you have noticed, may be restricted by an agreement between him and other partners. Now, if B, the lender, is unaware of this restriction imposed on A, the firm will be liable to repay the money to B. On the contrary, B's awareness as to this restriction will absolve the firm of its liability to repay the amount to B. If B is aware and then also he gives 1,000 rupees to A, now firm is not liable. B will have to take money from A only. If he does not know, then the firm will be liable. It may be noted that the above mentioned extension or restriction is only possible with the consent of all partners. Okay, unanimity has to be there. Majority rule is not there. No restriction by majority. Any one partner or even a majority of partners cannot restrict or extend the implied authority because this is provided by statute law. Partner's authority in an emergency. Section 21. Okay, the partner's authority in an emergency is implied authority in the case of an emergency. According to Section 21, a partner has authority in an emergency to do all such acts for the purpose of protecting the firm from loss, as would be done by a person of ordinary prudence in his own case, acting under similar circumstances, and such act binds the firm. Whatever be his authority. But in the case of emergency, if he is doing what a normal man would do, okay, in his place, then this act would bind the firm. So we will close our today's chapter here. Next chapter will begin with effects of admission of a partner and notice to acting partner and other stuff. Okay, we close this chapter here.